Facts of the case. In this case, the plaintiff was an engineering consultancy firm trading under the name Angkasa Jurutera Perunding Sendirian Berhad. The second defendant is also a consultancy firm founded by the plaintiff's personnel, Wu Hin and Dato. They had a joint project by the plaintiff with a partnership with the GHD company whose origin is Australia. Wu and Bin resigned from the company and withheld their shares from the sector. GHD followed the same suit and withdrew and demanded that the second defendant refrains from using the GHD in their company name. The second defendant changed the name of the company to Angkasa Consulting Services Sendirian. The plaintiff's concern was over the likelihood of the business being confused for the other, as both provided similar services, which is consulting engineers. The plaintiff then suggested that the defendant drop the title since it has a striking similarity with its name and they are both engineering. It was then held that Angkasa is a common word and its use did not require the minister's approval. The name is not descriptive, thus no company has a monopoly over. Next, the two firms, Angkasa Jurutera Perunding Sendirian Berhad and Angkasa Consulting Services Sendirian Berhad, are two different business entities distinct in name and management. And lastly, the defendant complied with the Companies Act 1965 under the Malaysian Constitution.
Hello, my name is Pavitra Anapramban Sivakumar and I'll be talking on the principles of law that had been referred in this case. Okay, so the legislation that had been used in Angkasa case is Companies Act 1965 and the provisions were Section 22, subsection 1, 2 and 7. Okay, this section means that except with the consent of the minister, a registrar shall not register a company's name which is undesirable or a company's name that the minister has directed the registrar not to accept for registration. Subsection 7 says that if the registrar is satisfied with the company's name and if the name does not contravene subsection 1, then the registrar shall approve the company's name to register and it shall reserve the proposed name for a period of 3 months. So, according to our syllabus, we are using the Companies Act 2016. So, the similar section with the provision used in Angkasa case is Section 26(1), 2, 3 and Section 27(5) of Companies Act 2016. These three provisions here is all about how a registrar shall approve a company's name to be registered. It has exactly the same meaning with the previous provision. Section 26(1) lists down a few conditions on how a registrar shall approve a company name, like it shouldn't be undesirable, it should be accepted by a minister and so on. And Section 26(2) says that a registrar shall have the power to accept or reject a company's name to be registered. Whereas Section 27, subsection 5 says that if the registrar is satisfied with the name and if does not contravene the condition Section 26(1), the registrar shall accept for the registration and may reserve the name for a period of 30 days. The provisions in Companies Act 1965 and 2016 have the same meaning, but there is only one difference, which is the period for reserving the proposed name. In 1965, the registrar may reserve the name for a period of 3 months, but in 2016, the registrar may reserve for a period of 30 days or longer. Now, moving on to the application of principle. In Angkasa Jurutera case, the second defendant's name is Angkasa Consulting Services. The plaintiff name is Angkasa Jurutera Perunding. So here, the both names has different meanings. So the plaintiff shouldn't have to change his name again in the first place. Next, plaintiff changing his name to Angkasa Consultant Group Sendirian Berhad actually exactly gives the same meaning with the second defendant's name, where both the company's name now has the word consult. So, applying the Section 22(1) of Companies Act 1965 here, a name which is similar to another company shall not be registered. So, what is done by the first defendant rejecting the plaintiff's proposal, it is right according to the law. So that's all from my part. Now let's move on to the next part, which is on Section 28 and 29 of Companies Act 2016. Thank you.
Next, it's under Section 28 of Companies Act 2016. It is a voluntary change of names. 3 steps required to fulfill. First, the company must make an application to change the name in prescribed form from the registrar. Then, the name of company can be changed under special resolution. Third, company have a duty to notify the registrar regarding the changes of name after special resolution has been passed. In order for a company to change its name, prescribed fee need to be paid and registrar satisfied that the name is compiled with the Act. This is an example of Form Section 28 under application for change of name. There must be a proposed new name of the company and the date of special resolution which had been passed, which is signed by the company secretary, which confirm the information are true. Section 29 Companies Act 2016. It is a compulsory change of name, duty of the registrar to serve written notice that have been registered where it should not have been registered. The notice to change the company's name shall be served within 16 days or longer if the registrar deems fit. If the company fails to comply, the registrar can change the company's name. If another company copied the name or brand establishment, the court will intervene if the company seek for a remedy. If the existing company suffer losses, they can sue for the other company. Case of Revertex Limited and another against Revertex Sdn Bhd. The defendant activity is similar with plaintiff, which is in the latex business. The name of the parties may create confusion, thus the plaintiff sought to protect their name. The word tax comes from latex and the word Revertex was not a description of anything. As their name is similar, it would create falsehood which they may connect to each other. The court held that the plaintiff attained a goodwill and a reputation. Any types of business will be controlled by Suruhanjaya Syarikat Malaysia SSM in compliance with Companies Act 2016. By referring to this case, plaintiff company's name, which is Angkasa Jurutera Perunding Sdn Bhd, is not identical with the second defendant company's name, Angkasa Consulting Services Sdn Bhd. In this situation, the word Angkasa is a common word which can be used by others. The word does not require to get approval from minister. The registrar have wider power to register and change the name. The court held it is not necessary for the company to change their name.
Okay, moving on to the next part, which is comparative approach with Commonwealth case. So there are two cases, which is the first one, Angkasa Jurutera Perunding Sdn Bhd against Pendaftar Syarikat, and another one case is South Pacific Airlines of New Zealand Limited against Registrar of Companies. Okay, for the first case, the fact is where the plaintiff intended to change plaintiff company names from Angkasa Jurutera Perunding to Angkasa Consultant Group Sdn Bhd on the ground that the new name of second defendant's company similar to the plaintiff company which named Angkasa Consulting Services Sdn Bhd. Plaintiff concern in this case is over the likelihood of the business being confused for the other as both companies serve similar services, which is consulting engineers. While the fact in this second case is where the plaintiff, a duly incorporated company, registered under the name of South Pacific Airlines NZ Limited, once again in 1962, made an application to the defendant, who is the Registrar of Companies, to change its name. The plaintiff intended to change its name to Airlines of New Zealand Limited, but the defendant refused such approval as it is likely to cause confusion with New Zealand National Airways. The reason that the plaintiff wanted to change its name was that a company incorporated in the United States of America known as South Pacific Airlines had been objecting the plaintiff's use of the similar name and threatened action for damages.
Hi, I'm Neelam. I will explain on the application of the principles in both cases. There are two principles under the common law to be compared, namely similarity of names and discretion of the registrar. Similarity of names. The test is laid down in the case of national timber. The question asked is, are the names of the company so much alike the person who under ordinary circumstances would be customers of such company for the commodities in which they deal are likely to be deceived into dealing with the new company in mistake for the old to the detriment of the latter? Based on this test, there are few questions to be determined: whether the two companies are dealing in the same commodity, whether the mistakes already took place, whether there are probability for the customers to confuse as to their identity, to the nature of the business carried on by two companies. In New Zealand case, in applying the principles, it is a conflicting issue in changing the name from South Pacific Airlines of New Zealand Limited to Airlines of New Zealand Limited, as the latter has similarity to New Zealand National Airways Corporation. These two companies are two different entities but hold similarity in the nature or commodity in business. National Airways is a corporation constituted under the New Zealand National Airways Act 1945, whose general function is to maintain air services for the transport of passengers by air within New Zealand and maintain necessary ancillary services. It conducts a trunk service throughout New Zealand with its subsidiary services to smaller centres. Whereas the plaintiff which do not own license to operate direct trunk services conduct services to main centres with intermediate stopping places in some cases at airport not serviced by National Airways. Both have similarity in the area of operation, namely from Auckland to Invercargill. There is no yet mistake happened concerning to the relation between both names. However, under the third question under this test, it can be said that there are high possibilities of confusion as to their respective identity. Despite the plaintiff having no intention to deceive, the similarity may well cause deception of customers unfamiliar with the rival operation of air services. Hence, the change of name shall not be done. On the other hand, applying the principles of common law to this local case, it is a question whether the change of name from Angkasa Jujur Perunding Senabarhat to Angkasa Consulting Group Senabarhat as a former may cause confusion for the second defendant company which named Angkasa Consulting Services Senabarhat. Both companies owned by the plaintiff and the second defendant deal with the same commodity, that is to say, as the consulting engineers. Under the second question, the plaintiff had actually received phone call meant for the second defendant, but taken from the court as a human error. The court view is that both companies are so different in terms of name, registered addresses, registered number, which the court affirmed from a whole perspective both of them are clearly have no similarity at all. Hence, there is no need to change of name. The discretion of the registrar. The principle was enunciated in the case of R against Registrar of Companies, where it is indeed the discretion of the registrar to exercise his power with regard to the registration of a company name, whether it is to be either identical with another registered company or so nearly resembling it as to be calculated to deceive. The court may only interfere by mandamus if it is proven either that the registrar had not in fact exercised any discretion in the particular case, or that he had been exercising it upon some wrong principle of law, or that he had been influenced by the extraneous considerations which he ought not to have taken into account. New Zealand applied this principle. It is provided that the registrar may decline his approval if the suggested name so nearly resembles the name of a company carrying on business in New Zealand so as to be calculated as to deceive, as in accordance with Section 31 Clause 1A, and also if it is undesirable as in accordance with Section 31 Clause 4 of the Company Act 1955. The court may review the exercise of registrar's discretion if this is satisfied that the registrar had applied a wrong principles or has taken extraneous matters into consideration in his determination. In this case, it can be seen that the registrar had not misused his discretion, as the court are in favour of the registrar. Malaysia also applied this principle and is provided under Section 22 of the Companies Act 1965 as well as under Section 26 and Section 27 of the Companies Act 2016. In this case, the first defendant is the registrar who rejected the application of the plaintiff to change the name on the ground that the new name was similar to the second defendant's name. The first defendant had only exercised his wide discretion under the Act as he was in opinion that the new name violated the provisions. The court was convinced that the registrar had not acted in any manner. Well, let's move on to the next, which is the decision of the court.
The court held in the first case, which is Angkasa Jurutera Perunding against Pendaftar Syarikat, is the company name of plaintiff and defendants were no way similar and clearly indicated as two different companies. In the South Pacific Airlines of New Zealand against Registrar of Companies, the court held that the proposed name requested by the plaintiff may be calculated to deceive or undesirable as it will cause confusion as the plaintiff proposed name so nearly resembled the name of a company business in New Zealand named New Zealand National Airways Corporation. In conclusion, the court dismissing the application in both cases.